Can I declare the meeting open to the public? Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted? Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that the Justice Bill clause by clause scrutiny and the oral evidence session with Sejini on their inspection of child criminal exploitation in Northern Ireland will be recorded by Hansard, and so I seek the committee's agreement to this. Is that agreed?
Agreed.
Okay. Can I remind members then that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration. Any members who have interests to declare in relation to today's business should do so now or when the particular matter arises. So can I ask members if there is any interest at this stage to declare? Okay. Agenda item number 3 then is draft minutes. Inform members that the draft minutes of the meeting held on Thursday the 12th of March 2026 are at pages 16 to 31 of the meeting pack. Can I ask members if they are content that the minutes are a true reflection of the proceedings of the meeting held on the 12th of March 2026? If so, I will sign the minutes. Agreed?
Agreed.
Thank you. Okay, agenda item number 4 is matters arising. Can I ask members if they have any matters arising for the minutes that they wish to raise? No? Okay. Agenda item 5 then is the Justice Bill clause by clause scrutiny. So can I refer members then to the tabled pack for the relevant papers, including a clerk's memo beginning at page 3, which sets out the committee position following the deliberations on each of the clauses of the bill and the proposed amendments following the deliberations at the meeting in January, February and earlier this month. Can I advise members that copies of the agreed committee amendments drafted by the bill clerk are included in the tabled pack, as well as the planned departmental amendments for members' ease of reference? Can I advise members that the committee will now undertake its formal clause by clause consideration of the Justice Bill and proposed departmental amendments? Can I inform members that I will proceed through the clauses of the bill and proposed amendments in order and put the questions formally? So can I seek the agreement of members to group clauses together which relate to similar areas of the bill for the purposes of putting the question? Are members agreed?
Yeah. Agreed.
Can I advise members then that where there are amendments to a clause, I will put the question on the amendment first. The question on each amendment that introduces a new clause to the bill will be put at the relevant point. So part 1 then, the biometric data, retention, etc. Clause 1, retention of fingerprints and DNA profiles. Can I inform members that the committee has agreed to an amendment to provide an enabling power for the retention and use of photographs? This will insert a new clause into the bill, so we will formally consider that after clause 3. Similarly, the committee's amendment to commence part 1 of the bill within 5 years of royal assent will be dealt with when we get to clause 33. So can I remind members that early in the committee stage, the Minister advised of the need for an amendment to this clause which would be necessary to plug gaps that arose during stress testing with the PSNI. The text of the Minister's planned amendment begins at page 19 of the tabled pack. These amendments relate to the replacement of the term reported with the term charged, to insert a new section 63NA to reference persons completing community-based restorative justice schemes, to bring in a grace period for DNA and fingerprints being held for individuals under investigation but not yet charged, and to allow for applications to the NI Biometrics Commissioner for consideration of review of materials being retained where the Commissioner thinks retention is appropriate. The Restorative Justice Amendment will also amend Clause 1 as follows. Clause 1, page 7, line 29, leave out community-based. Clause 1, page 7, line 29, leave out the word scheme. So can I put the question, is the committee content with the proposed ministerial amendment at Clause 1? Agreed?
Agreed.
Can I put the question then, is the committee content with Clause 1 as amended by the Minister? Content?
Content.
Okay. Clause 2 then, retention of fingerprints and DNA profiles, amendments. Can I put the question, is the committee content with Clause 2 as drafted?
Content.
Content. Clause 3, retention of fingerprints and DNA profiles, supplementary. Can I remind members that the Department has confirmed that a fix will be made to Clause 31 to provide the Assembly scrutiny procedure for Clause 3.10, so we will deal with that at that point. The Department's planned biometrics amendment proposes an amendment to Clause 3 to leave out 63S and 63W at line 18 on page 18 and insert and 63S. So can I put the question, is the committee content with the proposed ministerial amendment at Clause 3?
Content.
Content, thank you. Can I put the question then, is the committee content with Clause 3 as amended by the Department?
Content.
Thank you. New clause, retention, use and destruction of photographs. Can I remind members that the committee had agreed to bring forward an amendment to introduce a regulation making power to make provision for the retention and use of photographs. Can I put the question then, is the committee content with the amendment to insert a new clause to provide such a regulation making power? Content?
Content.
Can I put the question then, is the committee recommends to the Assembly that the new clause is added to the bill?
Content.
Content. That brings us to part 2 of the bill, which is the children's part. So clauses 4, duties of custody officers after charge. So can I remind members that at the meeting on the 5th of March, the committee agreed to table an amendment to add vulnerabilities to the range of considerations that the police must have regard to when making bail and remand decisions in children's cases. So can I put the question, is the committee content with the amendment to add vulnerabilities to the range of matters to be considered by the police? Content?
Content.
Yeah.
So can I put the question, is the committee content with Clause 4 as amended by the committee? Content? Thank you. Clause 5, police bail after arrest. Can I remind members that as per the previous clause, at the meeting on the 5th of March, the committee agreed to table an amendment to add vulnerabilities to the range of considerations that the police must have regard to when making bail and remand decisions in children's cases. So can I put the question, is the committee content with the amendment to add vulnerabilities to the range of matters to be considered by the police? Content? Can I put the question, and is the committee content with Clause 5 as amended by this committee? Content. Clause 6 then, court bail. Can I remind members, as per the previous clauses, at the meeting on the 5th of March, the committee agreed to table an amendment to add vulnerabilities to the range of considerations that the court must have regard to when making bail and remand decisions in children's cases. So can I put the question, is the committee content with the amendment to add vulnerabilities to the range of matters to be considered by the courts? Content. Thank you. Can I put the question in, is the committee content with Clause 6 as amended by the committee? Content. Thank you. Clause 7 then, arrest for absconding or breaking conditions of bail. Can I put the question, is the committee content with Clause 7 as drafted? Content. Thank you. Clause 8, considerations relevant to bail accommodation. Can I remind members that the committee agreed on the 26th of February to reflect its concerns and comments about the lack of a timescale for the commencement of Clause 8 in its report on the bill. That report will make clear the committee's stance. So, having said that, can I put the question, is the committee content with Clause 8 as drafted? Content. So clauses 9 to 11, the place of detention following sentencing, powers to sentence a child to detention amendment, and the powers to sentence a child to detention removal. So can I seek agreement of members to group clauses 9 to 11 for the purposes of putting the question? Are members content with that?
Content.
So can I put the question, is the committee content with clauses 9 to 11 as drafted?
Content.
Content. Okay, thank you. Clause 12 then is the youth custody and supervision orders. Can I remind members that had considered a potential amendment to review the operation of the new youth custody and supervision orders, having considered a response from the department advising that these will be captured in the Youth Justice Agency's workload statistics, the committee agreed at the meeting on the 12th of March not to proceed with a committee amendment if the reporting is already in place, and to consider the annual Youth Justice Agency statistics as part of its ongoing scrutiny work. So having said that, members, can I put the question, is the committee content with clause 12 as drafted?
Content.
Clauses 13 to 19, which is the place of retention following remand on custody, remand and custody exceeding 3 months, consideration of time spent on remand and custody, the place of detention in custody for contempt of court, and the removal of powers to remand or commit a child to custody. So can I seek the agreement of members to group clauses 13 to 19 for the purposes of putting the question? Are members content with that?
Content.
So I will then put the question, is the committee content with clauses 13 to 19 as drafted?
Yes.
Content.
Great, thank you. So new clauses 19A, 19D, organised crime groups, definitions, participation in criminal activities of an organised crime group, directing the criminal activities of an organised crime group and organised crime groups amendments, new schedule, organised crime groups amendments. So can I remind members that the department proposes to add new clauses to the bill relating to serious organised crime, and these are at page 33 of your table pack if you are following that. So can I put the question, is the committee content with the proposed departmental amendment to add new clauses to the bill to define what constitutes an organised crime group, set out what it means to participate in the criminal activities of an organised crime group, and to create the offences of participating in the criminal activities of an organised crime group and directing the criminal activities of an organised crime group as drafted by the Minister? So when I put the question, that the committee recommends to the Assembly that the new clauses and schedule are added to the bill. Sorry, I should have put that as a question. So can I put the question, is the committee content with the proposed departmental amendment to add new clauses to the bill to define what constitutes an organised crime group, sets out what it means to participate in the criminal activities of an organised crime group, and to create the offences of participating in the criminal activities of an organised crime group and directing the criminal activities of an organised crime group as drafted? Are we content?
Yeah.
Okay, then I put the question that the committee recommends to the Assembly that the new clauses and schedule are added to the bill. Content?
Content.
So that brings us to part 3 then of the bill, which is live links. Clauses 20 and 21, interviews and detention. So can I seek the agreement of members to group clauses 20 and 21 for the purposes of putting the question? Agreed? Yep, agreed. So can I remind members that while supportive of the clauses, the committee agreed on the 12th of March to table an amendment to introduce a new report on the effectiveness of the operation of live links in police custody settings. That will be a new clause, so we will consider separately after I put the question on these clauses. So can I put the question, is the committee content with clauses 20 and 21 as drafted? Agreed? Content? I'm taking silence as
Yes,
contentment. Okay. New clause, review of the use of live links. Can I remind members that the committee had agreed to bring forward an amendment to monitor and review the use of the live links provision in the bill as introduced. This is page 37 of your table pack. So can I put the question, is the committee content with the amendment to insert a new clause to make provision to monitor and review the use of live links? Content?
Content.
I put the question then that the committee recommends to the Assembly that the new clause is added to the bill. Content?
Content.
Okay, new clauses at 21A to 21L, which is the directions of participation by live link, enabling the public to see and hear proceedings, limited transmission, enabling the public to see and hear proceedings, broadcast, effect of live link direction, given a direction under this chapter, presumption of giving evidence by live link in certain cases, varying or rescinding a direction under this chapter, offences in relation to participation through live links, offences in relation to limited transmission or broadcasting, the meaning of live links for the purpose of this chapter, other definitions, and the consequential amendments and transitions provisions, public authorities for the purposes of section 21F, and then the amendments and transitional provisions. That's all basically the title and the headings of all the amendments. So can I remind members that the committee had discussed whether to bring forward an amendment to review the use of live links in courts and tribunals. However, this cannot be tabled until such times as the Minister's amendment is tabled. So can I seek members' agreement to reserve the committee's position on a potential review amendment until after the Minister's amendment has been tabled? Content?
Yeah.
So can I put the question, is the committee content with the proposed ministerial amendment to make provision for the use of live links in courts and tribunals as drafted? Content. So can I put the question that the committee recommends to the Assembly that the new clauses are added to the bill? Content.
Content.
Part 4 then of the bill is the administration of justice, clauses 22 and 23, the delegation of functions of the policing board and the removal of requirements to audit performance plans, etc. So can I seek the agreement of members to group clauses 22 and 23 for the purposes of putting the question? Agreed?
Agreed.
So can I put the question, is the committee content with clauses 22 and 23 as drafted? Content? There is a new clause then at 23A, the powers to photograph certain persons at a police station. The Minister's planned biometrics amendment proposes to insert this new clause, which introduces new Schedule 5, power to photograph certain persons at a police station. Can I put the question, is the committee content with new clause 23A to provide the powers to photograph certain persons at a police station as drafted? Content?
Content.
Can I put the question then that the committee recommends to the Assembly that the new clause is added to the bill? Agreed?
Agreed.
New clause 23B is the power to specify date of attendance at police station for fingerprinting, etc. The Minister's planned biometrics amendment proposes to insert this new clause, which will amend the PACE order to require attendance at a police station for fingerprinting, etc. So can I put the question, is the committee content with new clause 23B to require attendance at a police station for fingerprinting, etc. as drafted? Content?
Content.
Yeah.
Can I put the question that the committee recommends to the Assembly that the new clause is added to the bill? Content?
Content.
Clauses 24 to 26 is the consent for prosecution in cases of conspiracy to commit offence outside Northern Ireland, the death of child or vulnerable adult, the limitation of power to no bill alternative charge, and the examination of criminal proceedings through intermediary. Can I seek the agreement of members to group clauses 24 to 26 for the purposes of putting the question?
Yeah.
Content.
Okay. Can I put the question, is the committee content with clauses 24 to 26 as drafted? Content?
Yeah.
So there's a new clause 26A, accredited providers of restorative justice services. Can I remind members that the committee has asked CJINI for its views on the potential amendment to require pre-accreditation checks, and the committee can consider this matter further when a response has been received. In the meantime, the committee will wish to consider if it is content with the proposed departmental amendment, while reserving the right to bring forward an amendment at a later stage. So can I put the question, is the committee content with the Minister's proposed amendment to add a new clause to the bill relating to restorative justice? Content?
Content.
Can I put the question then that the committee recommends to the Assembly that the new clause is added to the bill whilst reserving the right to bring forward an amendment to the Department's amendment at a later stage? Agreed.
Agreed.
Clause 27 then is legal aid charges to be registrable in the statutory charges. Can I put the question, is the committee content with clause 27 as drafted? Content.
Content.
Clause 28, restriction of ordering taxation of legal aid. Can I remind members that the committee was informed of the department's intention to bring forward a further taxation amendment and to remove clause 28 from the bill. The text of the amendment was subsequently forwarded to the committee on the 3rd of March. However, given the timing, the committee has not had the opportunity to consider the amendment in detail and therefore agreed to note it. So the committee indicated on the 5th of March that it is not content with clause 28 as drafted and to note the Minister's intention that it will not stand part of the bill. So I have to put the question, is the committee content with clause 28 as drafted?
Not content.
Not content. Thank you very much. Okay, members?
Yeah, not content.
New clause 28A and 28B, the rehabilitation periods for convictions and applications in respect of certain sentences otherwise excluded from rehabilitation. It's 51 of your table pack, page 51. Can I advise members that the Minister proposes to table an amendment which will reduce rehabilitation periods for existing convictions and to allow more convictions to become capable of becoming spent. So can I put the question, is the committee content with the Minister's proposed amendments to add new clauses 28A and 28B to the bill relating to the rehabilitation of offenders as drafted? Content?
Content.
Yeah.
Can I put the question then that the committee recommends to the Assembly that the new clauses are added to the bill?
Content.
Content. Clause 29 then is the automatic review of criminal record certificates. Can I put the question, is the committee content with clause 29 as drafted?
Yes.
Content. There's new clauses 29A and 29B which are matters to be included in criminal record certificates, the rehabilitation of offenders, the excluded offences new schedule, and matters to be included in a criminal record certificate. So can I remind members that the committee sought and received agreement from the department to change the Assembly control for amendments to the list of non-filterable offences to the draft affirmative procedure. The department advised that necessary changes will be made in the final draft of the amendment prior to tabling at consideration stage. So can I put the question, is the committee content with the department's proposed amendment to add new clauses 29A, 29B to the bill relating to the criminal record certificates, subject to the necessary amendment to change the Assembly control for amendment to the list of non-filterable offences to the draft affirmative procedure? Content?
Content.
Can I put the question that the committee recommends to the Assembly that the new clauses and schedule are added to the bill, subject to that amendment also being made to the relevant part of the bill? Content? Agreed? So clauses 30 then is security of buildings used in court and tribunals. Can I put the question then, is the committee content with clause 30 as drafted?
Yeah.
Content.
Content. Thank you. Clauses 31, further provisions. Can I remind members that the department has undertaken to bring forward two amendments to clause 31. These are to change the Assembly control for the rule-making power at 63E11 in clause 1 to draft affirmative, and to provide that the regulations made under the powers of clause 310 will be subject to the draft affirmative procedure. The text of the proposed amendments has not been provided by the department. So can I put the question, is the committee content with clause 31 subject to the amendments being tabled by the department at consideration stage? Content?
Yeah.
Content.
Nearly there, members. Clause 32 is the interpretation. Can I put the question, is the committee content with clause 32 as drafted? Content? Clause 33 then is the commencement clause. Can I remind members that, as noted at clause 1, the committee agreed to table an amendment to require that Part 1 biometrics is commenced within 5 years of royal assent. Can I put the question, is the committee content with the amendment to commence Part 1 within 5 years of royal assent?
Content.
Content. The Minister's proposed biometrics amendment and the proposed rehabilitation of offenders amendment both make amendments to clause 33 as set out on page 17 of the table pack. So can I put the question, is the committee content with the department's amendments to clause 33 as included in the proposed biometrics amendment and the proposed rehabilitation of offenders amendment? Content?
Content.
Can I put the question then, is the committee content with clause 33 as amended by the committee and also by the department?
Content.
Content? Clause 33 is the short title. Can I put the question, is the committee content with clause 34 as drafted?
Content.
Content? Schedules 1 to 4. Can I inform members that the Minister's planned biometrics amendment makes amendments to Schedules 1 and 2. The planned rehabilitation of offenders amendment makes amendments to Schedule 4. So can I put the question, is the committee content with Schedules 1 to 4 as amended by the Minister?
Content.
Content? So long title then, can I advise members that as this is the end of the clause by clause consideration of the bill, the committee must now consider the long title of the bill. Can I further advise members that the planned departmental amendment on organised crime requires the long title to be amended. This is at page 36 of your table pack. So can I put the question, is the committee content with the Minister's proposed amendment to the long title to include to make provision about involvement in organised crime groups? Content?
Content.
So can I put the question, is the committee content with the long title of the bill as amended?
Content.
Can I advise members then that this now concludes the formal clause by clause consideration of the Justice Bill and of the planned ministerial amendments? Can I thank members and those who were previously on the committee for their cooperation? And can I inform you that the draft report on the bill is being prepared and will be circulated for consideration and agreement at the meeting on the 26th of March 2026, which is next week. Okay, members content?
Content.
Thank you very much for that. That was more painless than it. And sorry, thank you to Liz for all her work over the months. I think it was 18 months. 18 months. And of course that heats up as we get near the end of a committee stage. So thank you, Liz, for all your hard work and your continuing work as we approach consideration stage of the bill. Okay, members, that concludes that piece. So agenda item number 6 is an inspection of child criminal exploitation in Northern Ireland. The Criminal Justice Inspection Northern Ireland Oral Evidence. Can I refer members to pages 34 to 127 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from Sigini on their recent inspection of child criminal exploitation in Northern Ireland? Can I inform members that the witnesses providing evidence today are Jackie Durkin, the Chief Inspector of Sigini, and Maureen Earn, Lead Inspector of Child Criminal Exploitation in Northern Ireland Report Sigini. So can I welcome you both to the Justice Committee? You're very welcome here. Thank you very much for your time. And can I invite you, Jackie, to make an opening statement?
Indeed. Thank you very much. Chair, thank you for the invitation to this committee meeting and the opportunity to speak about our inspection of how the criminal justice system in Northern Ireland recognises, assesses and responds to child criminal exploitation. As you've mentioned, I'm joined today by Maureen Earn, who was the lead inspector for this inspection. It is timely that we're here today, given yesterday was the annual National Child Exploitation Awareness Day that encourages work across the United Kingdom to inform, educate and prevent child exploitation and to unite globally against it. I hope the committee found the briefing paper helpful. I would like to take a few minutes to provide some further information about the inspection and its findings before Maureen and I respond to any questions members may have. All forms of child exploitation devastates children's lives and their families. It is critical that we all recognise child criminal exploitation as child abuse, and it is subject to a robust response like any form of exploitation, where safeguarding and protection needs are swiftly assessed and actions identified and abusers are rigorously pursued. And we are mindful of the impact of any crime on all victims, knowing that exploited children can be both victims and perpetrators. This inspection was undertaken as part of CGI's annual inspection programme. Concern about the nature and scale of child criminal exploitation in Northern Ireland has been growing for some time and was brought into sharp focus by a number of events, including public disorder involving very young children. Senior police leaders have stated that children are being exploited, including by individuals linked to paramilitarism and organised crime. And child criminal exploitation has been recognised as a priority in the current policing plan for the first time. Against that backdrop, a cross-departmental definition and 2-year action plan were launched in September 2024, and this inspection sought to assess whether criminal justice arrangements were sufficiently developed to protect children and pursue those who exploit them. This was the first time we've inspected child criminal exploitation in Northern Ireland. It built on earlier inspection work in related areas, including child sexual exploitation, modern slavery and human trafficking, and a pilot joint inspection of child protection arrangements. Fieldwork for this inspection was conducted largely between March and June 2025 and ran in parallel with the follow-up review of the 2020 child sexual exploitation inspection. While recognising that tackling child criminal exploitation required a cross-departmental response, CGI's statutory remit focused on the effectiveness of the criminal justice system response. In particular, we examined the role of the Police Service of Northern Ireland, given its pivotal role in determining a child's pathway through the criminal justice system. Inspectors reviewed governance and policy arrangements, met with a wide range of statutory and voluntary sector stakeholders, and undertook detailed case file audits. Stakeholder engagement informed the focus of the inspection and reflected the experiences and voices of children who are experiencing or at risk of child criminal exploitation. Inspectors found that while child criminal exploitation was recognised as a growing concern, the criminal justice system faced significant challenges in recognising, assessing and responding to it. At a strategic level, there was no agreed criminal justice system-wide framework to baseline responses, monitor outcomes or measure success. While criminal justice organisations contributed to cross-departmental work, there was a limited strategy or policy specifically addressing child criminal exploitation. Data collection was hampered by the absence of specific markers or flags on PSNI and Public Prosecution Service IT and case management systems, meaning the criminal justice system did not understand the nature or scale of child criminal exploitation. At an operational level, awareness of and understanding child criminal exploitation was inconsistent, resulting in opportunities to identify and respond to child criminal exploitation being missed. Case audits showed that children were often treated as suspects rather than as potential victims of abuse. Safeguarding referrals were not always made in a timely way, and professional curiosity was not consistently evidenced. Inappropriate or victim-blaming language was sometimes used about children in the records we examined. The voice of the child was largely absent from police and prosecution records. Inspectors were particularly concerned about the response to children reported missing. The PSNI did not have sufficient understanding of the relationship between missing episodes and child exploitation. During fieldwork, I raised these concerns directly with the Chief Constable and requested immediate action. In response, the Chief Constable swiftly initiated an internal review and changes were made to police practice to improve safeguarding responses to missing children. The inspection also found that the PSNI did not have a clear, adequately resourced delivery model for tackling child criminal exploitation across the organisation. While inspectors evidenced pockets of good practice by individuals and teams, these were not embedded or consistently applied. Pressures on neighbourhood policing and community engagement, previously identified in our 2024 inspection of community safety and local policing, were impacting preventative work. Inspectors concluded that senior leaders must ensure sufficient resources, including within Public Protection Branch, are provided to respond effectively to all forms of child exploitation and abuse. Across the criminal justice system, awareness of the agreed definition of child criminal exploitation and understanding of the national referral mechanism as a safeguarding tool for children who may be victims of exploitation was limited. These findings closely mirrored those in our 2025 follow-up review of the child sexual exploitation inspection. That review found that while there had been some positive developments, progress in achieving long-term improved outcomes for children remained limited. Inspectors assessed that both strategic recommendations were only partially achieved. Of the 7 operational recommendations, 1 was achieved, 4 were partially achieved and 2 were not achieved. persistent weaknesses around data, strategic oversight, responses to missing children and the absence of the child's voice were evident in both inspections. The Child Criminal Exploitation Inspection made 2 strategic and 2 operational recommendations. All 4 were accepted and action plans were provided to CJI in advance of publication. The recommendations focused on developing a criminal justice system-wide outcomes framework, strengthening the PSNI's organisational response to child criminal exploitation and improving responses to missing children. It is clear that the Department of Justice and relevant criminal justice organisations, regardless of individual organisational, operational independence and governance arrangements, need to know what each organisation is doing to effectively tackle child exploitation, what impact it is having and how that system-wide data and information is used to better inform other departments, individual and cross-government collaborative action, and what difference that action is making in the lives of children at risk of or who are experiencing exploitation. How is it helping to deliver a programme for government priorities to create safer communities and end violence against girls? In closing, Chair, it is vital that the criminal justice system response to both child criminal exploitation and child sexual exploitation are effective. Many children experience multiple forms of exploitation simultaneously, and the same systemic weaknesses recur across both forms of abuse. If exploitation is not recognised early, children are criminalised rather than protected. Harm escalates and perpetrators remain free to exploit and abuse others. A joined-up whole system response is vital. Every professional working or in contact with children needs to know the signs of exploitation, ask the right questions and speak out. Everyone needs to think about the children in our community, learn the signs of exploitation and speak out. Working together, we can make a difference and protect children from abuse. We will continue to focus on criminal justice responses to the abuse and exploitation of children. Given the risks and impact identified, it is likely that a follow-up review will be included in a future inspection programme. Protecting children requires a consistent, child-centred response that listens to children, safeguards them effectively, and relentlessly pursues those who exploit and abuse them. I hope this overview is helpful, and Maureen and I will be pleased to respond to any questions you might have.
Thank you very much, Jackie. We'll go straight into questions from members. So, Emma Sheeran, Deputy Chairperson.
Thanks, Chair, and thanks to you both for coming in and for the presentation. You referred to it there in your oral briefing as well, that one of the key takeaways was that children were being treated as suspects as opposed to victims. And I wonder if you could comment on whether or not you believe that, you know, some training could correct this, or if this is reflective of a deeper cultural problem within criminal justice organisations. And then secondary to that, whether or not the current criminal age of responsibility is having an influence with regard to children being treated as suspects when they're actually victims of coercion or abuse.
So what we find, particularly around training, and what we find often when we do inspections, is the training is one thing, but embedding it in terms of practice and how that is quality assured to ensure that you know, what needs to be done and needs to be applied is actually happening. That's where sometimes the gap can be. So you can put any amount of police officers or prosecutors through training, but ultimately you need to make sure and have those quality assurance mechanisms in place to make sure, are things improved? How is that being transferred into practice? What is the experience of children who are coming into contact with the criminal justice system? So certainly this inspection found there was a lack of awareness about child criminal exploitation. There were pockets of good practice. As we often find, there were some amazing police officers and prosecutors doing great work, but it was inconsistent. It was too patchy. So what we think is that it needs to be more of a radical relook at making sure there is that consistency across policing and understanding what the police response across Northern Ireland, not just in particular communities or with a particular district or even police officer or prosecutor, but make sure that there is that consistency of approach across Northern Ireland. In terms of the age of criminal responsibility, I think regardless of what age the child is, children need to be seen as children. And what we found through this inspection was that there was that what we call adultification of children, where there's a presumption that if a child is over 16 and over the age of consent, they're not really looked at as if they're still a child. that those responses to them were, and we found evidence of that in case files, as you may be seen in the report, where there was some of the comments that were made or recorded about a child that it was a lifestyle choice, or they were a very resourceful young lady and this type of thing. So you want to get away from that and change attitudes and behaviours, as well as knowing what a clear understanding of what child criminal exploitation is and other forms of exploitation, and recognising that very often there's more than one type of exploitation going on. So what is an effective policing and safeguarding and protection response for that child?
I think I maybe just add to that in terms of, training and awareness is one of the 4 strands in the CCE, the 2-year action plan that has been developed across the departments. And we know in the police service response to the report, they are currently working on developing an e-learning package specifically to address raising awareness of child criminal exploitation. And I think one of the observations I would make is that it needs to be seen beyond the purview of specialist teams, within public protection branch. So it needs to be those frontline officers who are responding to call outs day and daily, and to actually see children in front of them, as opposed to a suspect. And I suppose just on the minimum age criminal responsibility, our perspective going back over many years of looking at youth interventions within CGI is that the minimum age criminal responsibility should be at least 14, which is recommended by the UNCRC. Yeah. And that is an important contextual factor in terms of this work.
Yeah. No, I would have thought so. Thank you. Thanks, Chair.
Okay, Brian?
Thank you, Chair. Thank you for the report and your attendance today. Can you explain to us the sort of criminal activity you're talking about, the sort of exploitation, what sort of categories you have looked into?
Yeah, so they're very wide. The case file review that was carried out by inspectors would have been a range of offending. So it could be like carrying drugs, trafficking drugs for someone. It could be stealing, could be children sent into shops or stores to steal to order. Can be public disorder, as we all know and is widely reported in Northern Ireland. And antisocial behaviour as well. So there's a range of offences, and I think what this report says very clearly is we need to know more about it. We need to make sure that there is good information about children who are either potentially or are being criminally exploited, and making sure that there's information gathered about that so we can get a better idea of what the problem profile is in Northern Ireland. And we don't have that at the minute. So those are, I would say, because we don't know that, a lot of that offending, whether it's violence, theft, drug dealing or moving drugs around, then that's the sort of thing that we need to know more about.
And sexual exploitation as well, that would also factored in.
Absolutely. Yeah. And what we find too is sometimes children who were involved in one form of exploitation could also be involved. So if a child was being sexually exploited, they might also be involved in criminal exploitation as well. And
in terms of early awareness, did you have any engagement with some other sectors, like teachers, youth workers? Social workers obviously would have might also first become aware about the role they would have in flagging up concerns, and just how, I'm sure there are procedures in place, but just have you any concerns about just that information at an early stage, being flagged up?
I think one thing that has been recognised, that this isn't just a criminal justice issue. This is an issue for the whole of Northern Ireland, and it's particularly an issue for health education, and for justice, but also for Department for Communities as well, in terms of children who are in contact with different services at different touch points in their lives. So children who are gone missing from school, or children who are needing services from health and social services, children who are looked after, but not exclusively, obviously, children who are looked after. So it needs a whole cross-government approach, and a really effective approach, and that's why the structures and governance arrangements are in place. But we were certainly focusing on making sure that the criminal justice system was joined up and collaborative, and we knew exactly what was going on in each part of the criminal justice system to inform that wider cross-government approach. But you're right, we all need to know what it is and to call it out. I think it's very easy, we can all be, out in our communities and see children and you sense that something's not quite right, but who's going to speak up? Who's going to call that out and say there's something not quite right here? What's going on? Why are those children out on their own, at 11 or 12 o'clock at night or wherever it happens to be? It's that professional curiosity or even that community curiosity of what's going on, and who can you raise that with? So it's not, like most things, doesn't just belong to the criminal justice system. Those children have probably been in contact with other services and other departments, and whether they've been at school or not in school anymore, there are other people and other professionals who should be looking out for where is that child, who are they with, and what are they up to, and what do you need to do about it to make sure there's an adequate safeguarding and protection response.
Well, one further question, leading on from that, in these matters, when children are being exploited into criminal activity, but they are themselves committing crimes, which agency should be taking the lead in that? Is it youth justice agencies, the police, is it social services, or a mixture of those? But who do you think should have the fundamental responsibility?
Well, I think it needs a cross-departmental, cross-agency approach. I think that's where you have to see that child where they are. You have to look at the needs of that child and what's going on in that child's life. So it may not necessarily be that there's one specific organisation in the lead. You have to find out what's going on with that child and being curious about that and seeing what sort of interventions or supports need to happen to better protect that child. But I think that what we found too through this inspection was sometimes it's parents who are exploiting their children, and certainly some of the case studies that we used in this report, and we're very careful to make sure they were anonymised, was the potential for, if it's a parent who's exploiting their child, then who needs to intervene, what's the type of robust response that's needed. And I think that's what it wasn't, one particular type or section of society. It was so widespread, and making sure that there was that consistency of approach and being alert to there's something going wrong here. How do we make sure the services that need to intervene do intervene promptly?
Maybe just the other thing to add there in terms of the concept in Northern Ireland is seeing child criminal exploitation as a form of modern slavery. That awareness was very low. So that is not, there is now a devolved national referral mechanism pilot introduced in Northern Ireland, and that brings together the Health and Social Care Trust and the Police Service of Northern Ireland, and that offers protections for children in terms of defence where their offending has been committed as a direct result of their trafficking. So I think that is very important as well, to pursue those options.
What did you say it was called again?
The National Referral Mechanism.
Okay, thank you, Chair.
Just on that point, that's a very important point. Did you see any differences in the way children were treated through ethnicity?
No, we saw in the records that ethnicity was documented in terms of the police records, but our samples were very small to make any determination across that. But what we could see and can see in the National Referral Mechanism data is that most of the referrals related to children who were from outside of Northern Ireland, so they have been trafficked to Northern Ireland, and a very low level of referrals for Northern Ireland, children within Northern Ireland, living within Northern Ireland, whereas that's quite different to the rest of the United Kingdom, where the number of referrals in National Referral Mechanism is seen as an indicator of the level, the nature and scale of child criminal exploitation. That's not the case here, but it is hoped that the new devolved pilot will see improvements in the number of referrals that are being made and a general increase in awareness of that mechanism here.
Jackie, you said about, there should be an onus on us all to step in, and all agencies step in when you see something amiss, a child out at 11 o'clock at night on the corner. That in itself will not be a crime and the child will not be committing a crime, but you still know there's something off. When is the trigger point, or when should an agency or a constable or a youth agency worker or probation board, all of the range of services and people that we train and are expert in this regard, when should they intervene in order to ensure that even though a child is exploited, that they don't come into the criminal justice system? You know, it's bound to be a difficult one. If it's everybody's responsibility, it'll be nobody's responsibility. But where do we get that in to find out about that child?
Yeah, well, I think what we found, certainly speaking to youth workers, they were very in tune with, you know, the children that they were coming into contact with, and I suppose it was that bit about at what point do you say, right, well, there needs to be a referral to social services here, or a referral to a discussion with local police. And I think that's the difficulty too. We know we've had these conversations round this table before about the absence of neighbourhood policing, community policing, knowing what's going on, sharing that intelligence across the community to say, well, you know, why is that child with that adult person? Do we have concerns about that adult? You know, is more than one person, you know, gathering intelligence and saying there's something not quite right here, so what do we do about it? I think youth workers are very in tune with, they're close to working with those children, and they disclose things to them, and I think they're well trained to know that if there's any sense that that child is being abused or being exploited, that the pathways into getting additional support and advice are there. And I think that's part of the shame as well about, you know, the reduction in resources for youth workers. They do amazing work. They are often the first person that a child will speak to when they are concerned about what's happening in their lives. And I think that together with more visible and more a police presence, more community policing as we envisaged, of police officers knowing what's going on in that community and what those children are doing. But I say every citizen, I think every responsible citizen, and I know it's difficult in these days, so people are reluctant to raise issues in case it's, you know, turns back on them or whatever. But I think when it's something like child abuse and child exploitation, we all have a responsibility to speak up.
Okay, Ciara, on the screen.
Thank you for your report. To be honest, it's kind of gravely concerning, particularly given that many of the recommendations from your 2020 report on child sexual exploitation remains unachieved. Jackie, I would like to ask maybe how confident you are that the system can respond effectively to this latest report. And then likewise, I get the fact that it has to be cross-agency approach to this, and it has to be at a community level. So is there any models of good practice that can be highlighted, or that you're aware of that does exist here in the North at a community level?
But before I get to that, I think in terms of the response, I mean, I was certainly encouraged by the response and getting action plans to these recommendations, but we know they're only ever as good as how proactively they're implemented. And I am encouraged. I mean, even the narrative, I think, has changed around child criminal exploitation and more of awareness now. I often find there's a gap between organisations who say at a strategic level, this is a priority, but when you scratch the surface, and you don't have to scratch too much at a operational service provision level, there's a gulf between what is printed and committed to as a priority, and then the experience of service users and children and adults in the system at the other end. So I think it's important that we make sure that priority translates into resource allocation, effective people, making sure that there is an adequate response and an effective response to any form of child exploitation. So that in terms of good practice, there was some good practice around the EPOC programme around, I can't remember the name of it off the top of my head. Maureen, can you?
There were multiple different projects there, and the evaluations of those were assessed have been positive in terms of outcomes for children and young people. I suppose maybe what I would add is, within the cross-departmental action plan, there are strands of work that will hopefully develop practice in terms of the development of a risk assessment tool and how responses will be developed across the agencies in terms of recognition of CCE and the support and safeguarding responses will be in place. But there's obviously that work is continuing at pace at the minute through the Safeguarding Board for Northern Ireland and also the Children and Young People Strategy reporting groups. I suppose our ask would be that those reporting groups really robustly, set their baseline in terms of what it is that we want to achieve and how are we going to monitor successful outcomes for children who have been exploited in Northern Ireland. And that's why our strategic recommendation, because we inspect criminal justice, that's why our recommendation was particularly focused at the Department of Justice, to be able to understand across the justice system, what is the justice system achieving? What is the sum of all of its parts? Not how much of everything is somebody doing, but what is that resulting in terms of the number of offenders that are disrupted, the number of prosecutions, how many children have been helped, how have they been helped? Are children back in school? Are they, back living in communities safely? Are they subject to less attacks? Are the number of missing episodes reducing? So there's a whole raft of measures that I think need to be drawn together across the justice system that will allow the justice system then to inform its conversations with its partners in Department of Health and Department of Education.
I think in terms of, how seriously, the police were, PSNI were quoted yesterday saying they now have a laser focus working with partners on child criminal exploitation, and that's something that we would look forward to reviewing and making sure the impact not only of these recommendations but how those cross-departmental structures are working together to make a real difference and be that step change in tackling exploitation of children across Northern Ireland.
No, I think that's critically important. Although you're looking at the criminal justice system, but it is cross-departmental, particularly health, education, communities alongside justice. And as we all know, that can be even more difficult. I think this is the first step. So it's about how the interagencies can all collectively work together, because you're going to need them all. They're all interdependent on each other. But it's still very alarming, and we must do our best to protect all children who may be exploited. So thank you for the report. It's definitely flagged up serious concerns. No, thank you.
Aoife?
Thank you. Yep. Thank you very much for the report, and it's certainly timely given the ongoing justice bill and the proposed amendments providing for new offences to tackle organised crime gangs. Some concerns were raised that these new offences lack specific defence for children who may have been exploited. Would your experiences from this inspection lend any concerns that children may need specific protection in legislation?
Yes, so in the report we have said that in the new offences, particularly around organised crime and also around the new child criminal exploitation offence and cocoon offences, that we would like the same protections available to children as there is already provided under the modern slavery and human trafficking legislation. So we would like to see the same protections there. I'm not sure if those are and have been built into the proposed legislation.
Thank you very much.
Thank you. Yeah. Connie?
Thank you, Chair, and thank you both for coming in today and presenting to us. There's obviously some really concerning findings in your report, but I think Paul touched on this, but what I was really concerned about was how little children have been referred through the National Referral Mechanism in Northern Ireland compared to the rest of the United Kingdom. And I was hoping you could talk a bit more to that and the kind of reasons that you found. Was it just the awareness and how it's used in the PSNI, or are there any other issues when it comes to that, especially when I think your data had no male children had been referred, and given what we do know about the levels of paramilitary exploitation of children, that's obviously really concerning. And if you could talk about the impact of not using that national referral mechanism, I think that would be really helpful. Thank you.
I think there's an issue in terms of the legislation and the duty to refer in Northern Ireland, because the legislation is different than it is in the rest of the UK. So I think that is something, although Maureen mentioned earlier about the pilot that's underway, and even the data coming out of that since January is encouraging in terms of the decision making around more local based decision making to refer children, and the volume of children that have been referred. I think it's about 13
since the start of January.
Yeah, since January. And when you compare that to the data that we have in the report, there's definitely what looks like a sea change in terms of consideration for referral. So that is encouraging. And if that model, that pilot model, works well, then it's about making sure that you evaluate that properly and say, well, where do we go from here? And in terms of Northern Ireland using that referral mechanism the way it's intended.
There was, just to add to that, I mean, there was in the organisations that we met, there was a very low level of awareness of the national referral mechanism, and again, I hope through the Devolve pilot work that will begin to increase. There, at the time of the inspection, the Section 22 defence under the Modern Slavery and Human Trafficking legislation had not been used in Northern Ireland, and that legislation was commenced in 2015. So there are lots of concerning elements around that, and the Department of Justice had commissioned the Ulster University and the International Organisation for Migration to explore the reasons why the use of the NRM was so low in Northern Ireland in relation to child criminal exploitation, and that's it. We have drawn on that within the report. But yes, it is around awareness and maybe a lack of clarity around understanding of CCE being seen as a form of human trafficking and not making that association, and therefore, you know, those offences not being progressed in relation to certain investigations. And we also, you know, picked up from both police officers and prosecutors that some a lack of clarity around, well, what would be required to pursue those types of offences. So I think that's where, if there was a cross-justice approach, that you would begin to look at, well, what are the barriers and challenges around using these offences and offences, and how can we unblock that?
Thank you. Yeah, I agree with a lot of what you said. I think the NRM really isn't awareness among a lot of agencies here. I think my only other question would be sort of just overall in terms of your reports. Obviously, the most recent one even found that there hadn't been much progress since the previous one in 2020, I think. And how have you been engaging with agencies in the PSNI particularly since your most recent report, and how confident are you that actions will be taken forward?
Well, we received action plans, you know, on all the recommendations were accepted and received action plans, and this is such a high risk, high harm area. I can't imagine that we wouldn't come back and look at this at some stage in the future and do a follow-up review on this report to make sure what actually has been done. So there is that concern that the media say post a report, and when it's a high profile issue at that point in time, that things look as if they're encouraging and they're starting off well, but it's about the momentum and the commitment to keep going with that. I think what I'm assured about too is the policing board, as a governance and oversight mechanism for the police, you know, they're getting regular reports on how that priority, that child criminal exploitation priority, what is the sense of delivery and achievement against that. So there are other checks and balances in place outside of the inspection process to say, you know, how are things improving? What outcomes are you achieving? Do we understand the scale of child criminal exploitation in Northern Ireland, and how is the justice system working with others to make sure that is a whole system collaborative response to it?
That's really helpful. Thank you very much.
Thank you, Connie. Maurice Bradley.
Thanks very much, Chair. Thank you very much for your presentation. I found it very interesting. And I suppose it's the first time there's been a dedicated inspection of child criminal exploitation. but at the minute there's no baseline, and without a baseline, it's hard to gauge if it's going to be a success or not. And what engagement have you had with? You've been engaging with the PSNI, but the PPS, or the Youth Service Agency, or the Department of Justice, or Department of Health, Department of Education, recognising that it's a multi-agency task that you sort out. Have you had any engagement with everybody that I've just mentioned there, or any of them that I've just mentioned?
Well, we've had engagement through this inspection and with other inspections, obviously with the main criminal justice organisations, but we would have contact with Youth Justice Agency, with voluntary and community sector groups. I mentioned youth workers earlier. But I suppose the difficulty is that I don't have the statutory remit to inspect the Department of Health or Education. It's through those cross-government, cross-departmental governance mechanisms that are in place to make sure that there is that robust response, and there is the cross-departmental committee that's chaired by a senior police officer, and making sure that child criminal exploitation and how joined up those responses are across Northern Ireland. So it is something that we're focused on, I suppose, if you like, making sure that the criminal justice system knows what's going on. We all know, we've all seen footage, we've all heard concerns, we've all spoken to, I'm sure each of the members here spoke to community organisations and leaders all the time who know that's what's going on, but nobody actually has a grip on the extent or scale of it to say, well, how do we make sure that we are responding effectively to this? Because time is short. We all know childhood is short. So if you don't intervene at an early point with a child, you can do lifelong damage, and that child will have real issues in terms of attainment and their mental and physical health. So it's really important that not only does the criminal justice system step up, but every part of government steps up to recognise what this is in our community and works together to do something about it. We obviously, as you mentioned, working with health, we did the pilot joint child protection inspection in the Southern Trust area with the Regulation and Quality Improvement Authority and the Education and Training Inspectorate. And certainly what I wanted to happen in terms of development of inspection is about more of that joint inspection, where organisations who inspect in health and in education provision, and obviously for criminal justice inspection, to make sure that whatever that model of provision is in the future, whatever services are developed in terms of response, that there is that joined up child protection inspection process put in place as well. But it's at very much at development stage. We did that pilot. We know that Ray Jones' report, the outworkings of that are still taking some time to decide what they're going to look like. But I certainly see that joined up inspection regime is as important when there are joined up services, to make sure that we can provide that assurance that they're operating well. And through the pilot that we did undertake and within our own current legislative remit, I think it's important that we look to develop that in the future.
I think I could maybe just add, I mean, Jackie said earlier that, you know, we were encouraged by the response to the report that we received from the police service, and we know in the interim that the service has adopted the definition of child criminal exploitation, which was developed. We know that they're working at the minute to develop a flag and markers on their systems to identify children who are at risk or experiencing CCE. We know that there are now the indicators in the Northern Ireland Policing Plan, so they will be making reports to the policing board, and that will include the number of NRM referrals that have been made by the police. And we know that they're working with the prosecution service to improve the quality of information that is transferred from police to prosecutors in relation to child criminal exploitation. So that is all very encouraging to hear, and then hopefully we'll see the outworkings of that at a future inspection. But that does lay the foundation for getting some handle on the nature and scale of this problem across Northern Ireland.
Yeah. Chair, just one wee quick one.
Okay.
With your permission. Yeah. Some members have already alluded to the the work initiated since 2021, and the ongoing work since then. That would mean that you're not starting really from a baseline of zero, that you already have some institutional momentum that can be accelerated. So I wish you well on that there. And again, just thank you so much for that very valuable presentation.
Thank you very much.
Thank you, Maurice. Brian, you wanted in?
Yeah, I just want to come back. It's similar to the question I asked earlier, but I want to talk to it from like real life situation. So I'm representative in North Belfast, and so at interface areas there are regular outbreaks of trouble, and quite often it's children. If I'm driving up the Crumlin Road, there's a good chance I'll see groups of children hanging around and almost waiting for each other, and then it can result in attacks on homes or stones being thrown across roads and so on. So in terms of how the police respond to that, this children maybe from 10 years up, and I go to meetings with community representatives, and people talk meeting with the police as well, and what should be done about this. So, and in a situation like that, you don't know, is an adult sending the children out to do this? Are they being exploited, or are the children just doing it as recreational rioting? And then what the response of the police should be, and when they do apprehend children involved in this, whether they take them home to the parents, they would hope the parents would react in a certain way, but the response from the parent might not be supportive of bringing the activity to an end. So it's again just to ask about the different agencies involved, and I think social services do have an important role, and for parents to be aware of their responsibilities. So again, in practical situations like that, and again, I'm thinking the police, the Youth Justice Agency, social services, or any other. I know schools potentially can play a role as well, and community organisations, youth workers. Just again, your view on that sort of situation, how it should best be responded to.
I think what we found was that, and we mentioned it about, it's very clear in the report about that child-centred approach, and saying, listening to the voice of the child, and whether it might not be a police officer, it might be a social worker, or it might be a teacher, or it might be another trusted adult, to find out what's going on with that child. Did somebody send them out to riot? Did somebody tell their parents to send them out to riot? Are they involved in any other sort of antisocial behaviour, or is this completely out of character for that child? So I think it's very difficult to be generalist about the solution or the response. It'll
That's Morris.
I hope whoever's at the other end of that is okay.
Yeah.
Morris's microphone, you can say.
All right.
I agree with us.
Morris doesn't agree with what we're saying. So I know it sounds like that's not an answer, but in truth it is an answer, because it really depends what's going on with that child and with their family, and what sort of pressures they might be under, or what else is happening around them. But it's about the point of making sure somebody intervenes to find out what is happening and what's the best support or response for that child. And it may not be, taking them into a police station and questioning them there, or whatever it happens to be, may not be the right thing for them either. The Youth Justice Agency, I think I'm right in saying that what we found was the Youth Justice Agency were probably the only organisation that had kind of recognised what that kind of response might look like, and what they might be doing in that space, and that was encouraging. And I know it's really difficult. We've all done it. We've all seen those things happening in pictures of children out rioting, thinking, well, where are the parents, and why is that child being allowed to do that? But it is very much about seeing the child as a child, rather than there's somebody who's throwing a brick at a car, or a police Land Rover, or whatever it happens to be. And we understand sometimes that's really difficult to do. But in essence, if that child doesn't get that intervention at the right time, well, it has lifelong consequences for them.
There are opportunities through the work of the custodial services within the Youth Justice Agency in terms of their earlier stage diversion work, where they'd be seeking very much to avoid the criminalisation of children and drawing them into the justice system. It's definitely the research would indicate that the younger a child is engaged with the criminal justice system, that child is more likely to be drawn into the system more fully. So what we're really talking about in that space is the step before they're even involved in terms of that preventative work, and that's certainly a key strand of the 2-year action plan that has been developed at the minute.
No, I mean, every time I'm involved in conversations about this issue, I do feel that social services have an important role to play, though.
Yeah.
You know, and to impressing on parents, you know, their responsibilities, you know, and you know, where they're neglecting their responsibility, you know. Okay.
Okay, Doug Beattie.
Yeah, it's just a brief one. I wasn't really going to come in, but I've heard this whole discussion that we've had, Jackie, and thank you for your presentation. It's as ever really useful and very telling. But we never talk about the victim. We always seem to miss the victim, and I know we're talking about child exploitation, but if that child has been exploited into criminality, there's going to be a victim at the other end of this. And what do we do in regards to the victim to understand it? Because what we're talking about in some cases here, we're not talking about 10 and 12-year-olds or 14-year-olds. We're talking about 17-year-olds, what many people will still refer to, whether people like it or not, they do, as young adults. But and they may be involved in criminality where there is a victim. So how do we tie this in with supporting the child who's been exploited, but also supporting the victim that's been created, and hopefully helping the victim understand the crime that's been perpetrated against them by somebody who has been dragged into an exploitative sort of relationship with somebody else?
I think in my opening statement, I was very clear that we do really recognise that, you know, there are victims who are involved in circumstances where children who are being exploited have committed offences. But what we also find that those children can very often be victims themselves. So there's that duality, and sometimes, depending on the victim or the crime, sometimes they want a more restorative approach to that child. And 17 or not 17, they're not an adult, they're still a child. And that's the difficulty, is the long road for some of those children that have led, who time and time again, you know, some of the cases that were reviewed in the case study, you know, children who'd been involved and in contact with the police maybe 30, 40 times until they got to the point that they were 17. So who was making the effective interventions in terms of, you know, safeguarding and responding to abuse of that child before they got to that point of being that 17-year-old? And what we find as well is that transition of when they turn 18, it's like, right, you're an adult now, and forget about everything that's gone before. What's the transition into the adult system? So I understand how difficult it can be for some victims, but not every victim wants a child to be prosecuted and to have a conviction for something that they've done, and it depends on what that response is. But what we do find is there is often a long road that leads to that point, and there are opportunities for interventions that haven't happened. And I'm not in any way negating the impact of crime on any victim. But as I say, it's not every victim that wants to see a child prosecuted and have a criminal record and deny them potentially of life choices in the future. I think that transition piece into, you know, once you turn 18, that's it. I think that is an area that needs to be looked at, not only from the criminal justice system, but from social services as well, and how a lot of young adults struggle in that space.
Yeah, and sorry, Jackie, and I wasn't for a minute thinking you weren't minimising victims, and I just it didn't. I just felt it needed to be spoken about a bit more in regards to victims, and you're absolutely right. we are still talking about the child. And I guess the whole point is of this, when we look at this and we look at the strategy, is how do we get upstream of this? How do we get upstream to try and divert them before they get into that later age sort of criminality? And that's really what I was talking about.
Yeah.
But it's difficult in a society when you are the victim and the perpetrators are 17-year-olds, and it's continuous perpetration by these ones, maybe antisocial behaviour, and that's where I think there's a real difficulty sometime in the perceptions that some have in what we're trying to achieve. And I don't think anybody wants to criminalise children of any shape or form. I certainly don't.
Yeah, and absolutely, I think there is that point about, you know, early intervention and education, and now we are at last at a point where you have that agreed definition, and the definition in of itself will mean nothing unless that translates into really effective assessment, intervention, services provided to support, and that, as I said earlier, professional curiosity around stepping up and speaking out on what happens with that child, because we did see it's difficult for everyone. I totally recognise how difficult it is for police officers and prosecutors as well when they're in contact with those children, and particularly children who constantly go missing but are treated as a cause for concern rather than treated as a missing child, and making it like it's just something to do. That's just how they are, rather than saying, why is that child gone missing from that children's home for 3 or 4 days? Did we actually get somebody who they might trust to speak to say, well, who were you with and what were you doing? Are we pursuing those people that they've been with? Because what we found from the case files were sometimes that was just, oh right, they're back and they're safe and well, nothing to see here, move on, till the next time they went missing. So there are lots of opportunities to intervene earlier on, upstream, to recognise the signs and making sure that everybody who's in contact with those children, whether they are a youth worker or a teacher or a police officer or whoever it happens to, a youth justice worker, to say, right, there is something not quite right here from what they're disclosing or not disclosing, or who they're associating with, or they've suddenly got a couple of phones on the go, or they're not going to school anymore. So we all, we recognise there are signs to say there's something not right here. So who speaks out and who steps up?
I think just to add in terms of, some of the case studies, do show that there were early opportunities to intervene, and ultimately the earlier exploitation is identified and a safeguarding response is placed around that child, then the less likely there are to be victims of subsequent offending if there's an effective response at the earliest opportunity.
Perfect. Listen, thank you, Chair.
Thank you, Doug, and thank you very much, Jackie and Maureen, for your presentation, your question or your answers here today. It's been very, very helpful. So thank you for your time. Okay, members, we will move on then. Agenda item number 7, SL1, the Police and Criminal Evidence Northern Ireland Order Codes of Practice Order 2025, Department of Justice Oral Evidence. Can I refer members to pages 130 to 716 of the meeting pack for the relevant papers? Can I remind members that the Department of Justice proposes to make a statutory rule under power conferred by the Police and Criminal Evidence Northern Ireland Order 1989 PSNI. The rule is subject to negative resolution procedure. Can I remind members that at our most recent consideration of the SL1 on the 26th of February, the committee considered a draft note by the department which it is proposed will be published alongside the interim version of Annex L of PACE Code C. The note highlighted that the Chief Constable is responsible for providing corresponding operational guidance and instruction for officers and staff in conducting or being present at searches of detainees, and that the PSNI has adopted the National Police Chiefs Council's, the NPCC, interim guidance searching by transgender officers and employees of the police and searching of transgender detainees. It was agreed at that meeting that the department would update the draft note to explicitly state that there will be no career detriment to an officer who declines to search a transgender detainee. Can I inform members that the Department has now provided the Committee with an updated draft note which is at pages 138 to 139 of the meeting pack. The Department's correspondence also addresses some of the questions that members had raised in relation to section 1.3 of Code C. The revised Annex L is included in the meeting pack beginning at page 144. Can I inform members that Lisa Bowl, Head of Police Pace Policy and Legislation branch is present at today's meeting and can come to the table if members have any questions. Can I seek members' views on the revised note to be published alongside with the PACE codes? Can I just state that I welcome the addition, the last sentence on that note. I think it's very welcome, and I think it does clarify the situation as we thought it would, but I think it just gives officers that further reassurance that not only is it in the NSPCC guidelines, but then also now in a note accompanying our PACE codes. So I welcome that change. Doug, you want to come in?
No, I guess just to echo yourself, I mean, looking at this and everything that we've done to scrutinise it and everything that the department has done to try and meet the concerns that we've had, I am now content with what they've done, and I'd be happy to go forward as it is now. Okay,
thank you very much, Doug. Brian?
Yeah, no, well, I agree with Chair, with yourself and with Doug, and I think it vindicates our approach to this, that we wanted to see that reassurance for officers, that they wouldn't be put under undue pressure and that there would be no career detriment. And we didn't want that just to be told that was a way of working. We wanted to see it in black and white, in writing, preferably in the PACE code, but we have this note which has now been published alongside the annex and the confirmation about the NPCC guidance being adopted by the PSNI, by the Chief Constable, being implemented, and that specific reference, as you've said in that last sentence, of the no career detriment to any officer or staff member who declines to conduct a search involving a transgender person, or to a transgender officer exempt from searching. And I think we have got that to the position that we wanted to know that officers would have that assurance.
Okay, thank you. Emma, do you want to come in?
Just to say, specific to codes H and I, we still have the same position on them, that we're not happy, and on that basis we wouldn't be supporting the...
Okay, thank you for that. So can I then can I ask members to consider if they are now content with the proposal for the statute rule to bring into force revisions to PACE codes of Practice A to H and the introduction of the new code of Practice I, given into consideration what Emma has just said? Can that be noted? So are members then agreed?
No.
Yes, agreed.
Yeah. Do you want to take a formal vote on it?
Yeah.
I think we should do.
Yeah?
Yeah.
Okay, we'll have a formal vote then. So can I ask, are members content with the PACE codes of Practice A to H and the introduction of a new code of Practice I? All those who are content signify by raising your hand. Your hand's up, Connie, so I take that you want to speak. Yeah. You want to speak or you want to vote? I suppose.
No, I'm just raising my hand to say I'm content.
Content. Okay.
Chair, just to say, Morris Bradley, as he sent me a text, having internet issues, kicked out of the meeting, invalid to rejoin. I've emailed waiting to get back on again. Just maybe it'll not affect the outcome, perhaps, but anyway, unfortunately he's had an internet issue there.
Yeah, sure, okay.
Doug straight through the cable.
Flip the screen. So, okay, and then against. Okay.
Just to confirm then that in favour then are Brian, Doug, Connie and yourself, Chair, and then against Ciara, Aoife and Emma.
Okay.
So
that'll do. We'll move on from there. If members are content then, it's agreed. Okay, thank you very much, Lisa, for being here today. We really appreciate that. I'm glad you weren't called upon. Okay. Agenda item number 8 then is correspondence. Can I inform members that there is a correspondence memo and 9 items of correspondence at pages 718 to 823 of the meeting pack. Can I advise members that I will draw their attention to 5 of the items of correspondence, and then all members can have an opportunity to comment on others. So 8.2, 8.3 and 8.4. Can I remind members that at the meeting on the 12th of February, members agreed to write to the Department of Justice and the Policing Board to clarify where the guidance to medical practitioners on injury on duty awards can be assessed. This was following correspondence to the committee from an individual stating that the guidance wasn't easily accessible to the public on either the Department's or the Policing Board's websites. Can I inform members that the Department and the Policing Board have both now replied to the committee? The Department's reply at item 8.2 states that it does not publish the guidance on its external website, but it has provided the committee with a copy to pass on to the individual who raised the matter. The Policing Board's response at item 8.3 acknowledges the difficulty finding the guidance and has now made it easier for the public to access. However, since the Policing Board's response, it has come to the committee's attention that the guidance has been taken down from the website. Can I inform members that the same individual who raised the query about the access to guidance to medical practitioners on injury on duty awards has provided further correspondence to the committee seeking clarity on whether the guidance has been withdrawn and the reasons for this. So can I seek members' agreement to forward both the responses from the Northern Ireland Policing Board and the Department and a copy of the guidance to the individual who raised the matter with the committee, and inform him that the committee is aware that the online guidance has been withdrawn from the website, and with his consent will forward his questions on the reasons for this to the Policing Board for response. The members content. 8.8 Inform members that the Public Accounts Committee has forwarded to the committee correspondence from Extern regarding the future funding of their prisoner support project. The correspondence highlights that Extern pilot programme short-term prisoner support project will reach the end of its pilot funding on the 31st of March 26 and will not be able to continue the service in the community without cross-departmental funding support. Extern states that it has written to the Departments of Communities, Health and Justice to request the necessary cross-departmental funding to sustain the project. Can I seek members' agreement to forward the correspondence to those 3 departments to ask what consideration has been given to providing funding for this project? Agreed. Then 8.10, inform members that the committee has received correspondence from unsilenced victims of NDAs raising concerns regarding the misuse of non-disclosure agreements in charity, faith and education sectors. This correspondence requests that the committee give consideration to legislative reform to prevent the misuse of NDAs, as well as a request to meet with the committee in order that they might provide oral evidence on their lived experience of how NDAs operate in practice and how legislative reform and safeguards can be most effectively framed. Can I seek members' agreement to advise the organisation that the charity, faith and organisation sectors fall outside the committee's remit, and to forward the correspondence to the Committee for Communities and the Committee for Education for any action that they may wish to take? Finance? Yeah, we could add finance to that too. Yeah, Doug, you want to come in on this? No? Yeah.
Yes, I can, Chair. And just to express an interest is that I've met with these individuals previously in regards to this. I think one of the issues they're raising, Chair, is that some of the outcomes of the NDAs actually falls to the courts and tribunal service.
Yeah.
And that is they're not registered. An NDA and the reasons for an NDA is not being registered. So any future employer, for example, can't see a reason why an NDA has been entered. And I think in that area it does affect justice because judges no longer give a reason for an NDA being agreed, just that one has been agreed, and it no longer goes on to the public interest register either. So it might be something to consider, particularly with the investigation into the Presbyterian Church. I think it's going to be something that's going to be on our radar, maybe not this month, but certainly in the coming months.
Okay, thank you for that. Is it something then we can, under the guise that Doug has said, go to the Department of Justice on?
Chair, the committee did previously write to the department on that issue. I'll recirculate that correspondence.
Okay, and maybe we could
Um,
send that out then to, if it's okay to send it out to the charity,
To forward on
the
to the charity,
organisation
yeah,
involved.
that could be done as well. Yeah.
Would that be okay, Doug? You agree?
Yeah, I'm more than happy. Sure. I just think. Well, I don't know. I mean, I'll float this, but I would think the committee needs to hear their voices to understand just how coercive NDAs can be and damaging that it can be. And the process we have for NDAs here in Northern Ireland isn't really fit for purpose. But if the committee's not up for that, or you, Chair, don't think we should, I'm more than happy to circulate the what we've got already.
Could we maybe in the first instance send them out what we've already got received? We can also send it
Sure.
on to the committees of communities and education and see if they feedback anything before we'd make a decision on that. Would that be okay? Brian, you want to
Yeah,
in on
Chair,
this?
absolutely.
I think it's a very interesting letter, and it's an issue which has, raised its profile in the public arena with a number of cases recently. And I note that their letter refers to legislation, in England and Scotland, and it would seem we are falling behind. And sometimes it's commercial interests, but if it's to silence, serious malpractice, that is a public concern that we would all share. I would be interested in hearing from them at some stage. I appreciate where we are in the current mandate. For what it's worth, I had an oral question due today, so I put this question to the Justice Minister. I'm happy to circulate the answer I get. I've asked, in view of the legislation which has happened elsewhere in the UK, has she any plans to make any changes regarding NDAs? I mean, the two types of NDAs, non-disclosure agreements, and what's the other one they refer to? Non-disparagement agreements. I don't know if we have that distinction here.
The question is whether that falls within the Justice Department's remit.
If it's part of a justice ruling, it's hard for us to ignore it. But yeah, well, I'll see what response I get back.
Well, we see what response we get back. We can probably put the decision to have them up on ice to see just what comes back first, and then we can certainly make that call a future meeting. Is that okay?
Yeah, I'm content with that.
Okay, thank you, members. Are any other members then wanting to bring up any other of the items of correspondence set out in the correspondence memo in the meeting pack?
Did you cover 8.8?
Yes.
Yes.
Okay.
The extern.
I think it's the other committees.
Yeah.
Yeah, perfect. Sorry.
Okay. Moving on then is agenda item 9, forward work programme. Can I inform members that the department's proposed forward work programme for April is at pages 8 to 5 of the meeting pack, and the latest draft of the committee's forward work programme can be found at pages 827 to 832. Can I advise members that the department has advised that several items in its proposed forward work programme are subject to external matters and may not proceed as planned. So can I ask members if they are content to schedule the proposed work items from the Department of Justice into the committee's forward work programme? Is that okay? Yes. Can I advise members that the committee team is liaising with relevant organisations to schedule some of the evidence sessions or visits previously agreed by the committee, which are listed at pages 831 to 832 of the meeting pack. Agenda item number 10 then is chairperson's business. I have no chairperson's business to report. Agenda item number 11, any other business. Can I ask members whether they have any other items of business that they wish to raise today? No. Okay, then agenda item number 12 is date, time and place of next meeting. Can I advise members that the next meeting will take place on Thursday the 26th of March 2026 at 2 p.m. in room 30 Parliament Buildings. I adjourn the meeting. Thank you.
Committee Room 30. Sound. Committee Room 30. Sound.